Muy bien, pues buenos días.
Good morning, everyone, and welcome to the second day of the doctoral seminar of European Studies of the Charles V European Award that was given to Angela Merkel. The fortune of being together, guaranteeing the cohesion of Europe. We're going to start the second day with Yolanda López Nieto, whose work will be introduced by Frédéric Martin Wilmats, who's a teacher of constitutional right and political science he's the director of the legal department and the co-director of the chair of culture of Euro-Atlantic security in the University of Valencia. He was once a recipient of these scholarships, of the first edition of these scholarships. Frédéric has been working with us for many years. He has been living in Spain for many years, and he has held really relevant and outstanding positions in the academic world. It is a great honor to have him here. Frédéric, thank you very much for being with us, and the floor is yours.
Bueno, antes de todo,
Thank you very much, Miguel, for your introduction. I promise that I won't take too long. I always say the same thing.
pero no puedo dejar
I
ese momento sin dar las
can
gracias a la
waste
Fundación
the opportunity to, of course, thank the foundation.
porque a veces
Indeed,
cada una
my relationship with the foundation started 20 years ago.
a todos los que estáis aquí disfrutando.
I want to wish you all to enjoy this moment because you have an opportunity,
de continuar en esta
and I really hope that you continue cooperating with the foundation because it can be a very fruitful relationship. We are going to start the day with a very major topic, particularly for lawyers, and not only for lawyers, because the theme that Yolanda will cover is something that, as Miguel said, and as you can see in your agenda, in your program, is freedom of movement in the process of building European integration and citizenship. We have to, when we address this, we have to consider different regulations and different levels of law. Constitutional law is involved. We are going to cover a very important dimension, which is fundamental right. What is fundamental right? This is a very interesting topic. Starting from that point, often there's confusion between fundamental rights and human rights. A human right is a fundamental right, but a fundamental right is a human right? That is one of the classic interpretations of conceptual differences. But beyond conceptual aspects, in the legal arena, we will see how there are aspects connected to residents, freedom of movement, and there is another additional dimension that goes beyond law, and that can be a subject of debate, and that can feed into Yolanda's thesis. We have the economic dimension, the social and cultural dimension, etc. There are several approaches to this because this is aspect that has a holistic dimension. We obviously need a point of departure. In this case, is the legal domain. Here, we are in a space where each and every intervention can benefit from others' contributions. That is, there is this cross-cutting relationship between all of you. You can all benefit from moving out of working in silos. So without any further ado, Yolanda, you have all the time and all the attention from your colleagues. Thank you very much. Good morning, everyone. I would like to first thank the Yuste Foundation for making my presence here possible because, as it was just said, my topic is incredibly of a cross-cutting nature. Yesterday, I learned very much, and I hope to keep learning today because indeed I will um, approach my topic from a legal perspective, being fully aware that this is a fully cross-cutting domain. History, politics have an impact on my topic. So this seminar is fundamental and it's very useful for me and my project. So today I will talk about freedom of movement in the process of building European integration and citizenship. And I will talk about the impact of European citizenry in this right. I will just approach a small part of a larger project where we study all fundamental rights in economic integration. My thesis is on the Spanish constitutional law. So I will focus on freedom of movement in economic integrations. This project is just started. We have been working in it for very few months. So what I will share with you are the general guidelines or the point of departure of our study. And I will share with you the preliminary outcomes. On the other hand, when we talk about the freedom of movement in the framework of regional integration and European integration more particularly, it is important to point out that we're not just talking about passports or open borders, tourism, or Erasmus grants. Here, we are talking about one of the most fundamental pillars of the social and legal construction of Europe. Talking about the evolution and the history of this right is talking about the evolution of the European story and the story of a transformation. So I will adopt an approach, a compared and integrated approach, and I will talk about this general theory that will be extrapolated to the European experience. Let's talk about the evolution of integrations and freedom of movement. Then I will talk about the evolution in the treaties of the European Union, and I will focus on its origin. I know that there's lots of derivative law and a case law of the Court of Justice. Then we will focus more on the right and the union citizenry. And lastly, I will share the outcomes. Let's start with the beginning, please. If I may. Let's start with the general theory of economic integrations. And there are 4 stages of evolution. Before I get started, I want to point out that these 4 stages of evolution are not perfect and they're not stages that in practice can be clearly differentiated. It's just stages in theory that allow us to study the different stages and where they're leading to and the current point. Free trade zone, a customs union, and well, we start with the free trade zone that involves excluding or eliminating customs. A customs union barriers are deleted in member states, and the and tariffs are eliminated, and there's a common regulation. Common market, the third one, together with the free movement of trades that appears in the previous stages, establishes the free movement of capital, services, and people. And a very important characteristic is that something is added up, which is the necessary equality that must exist in the exercise of all economic activities in all parts of the territory of integration where we are at. And lastly, we have the economic and monetary union. If you remember correctly, the European Union, we said that was unique. And when it comes to economic integrations and regional integration, this is necessarily the case because the European Union is the only integration that is close to the last stage, the monetary and economic union. If we pay attention to the more specialized doctrine, it is pointed out that the European Union is the only integration that has consolidated the single market in a full way. There are many integrations that are close to this stage, for example, CARICOM. Regarding economic and monetary union, this is not something that is agreed because there's just one experience in the whole world that is close to this completion, which is the European Union. In this stage, there must be a total economic convergence that creates a very complex monetary structure. But I must add that in this stage of economic integration, integrations must be beyond economy. There must be a political convergence and a political shared project among all the states that are part of these types of systems. If we analyze the role of freedom of movement in the evolution of the economic integrations, we find two groups of stages that are fully differentiated. In the area of in the free trade area, freedom of movement is only recognized as long as people are working or traveling for economic reasons. At this stage, freedom of movement is an economic instrument that serves to complete economic goals. So people only exist as long as they are workers. I work, therefore I exist. What happens as we move forward to the common market stage? Workers' rights expand and are applied to citizens. People are no longer economic instruments that help us to achieve economic instruments, but are perceived as citizens. There's a more social perception of economic integrations. And this is how gradually the fundamental right of freedom of movement starts being built as we know it. And in parallel, as we move forward in the economic integration stages, we move closer to the creation of citizenry because the role that people have in the integrations changes over time. What is citizenry? There is no single definition that can be applied to all citizenry models that we find in the world. Today, I will adopt the following definition: a set of faculties, duties, and legal protection that citizens have according to a system. And it is also connected to the access to political participation and the feeling of belonging. Rights are political, civil, and social, and progressively will also be cultural and economic. The first one is the freedom of movement. With the appearance of economic integration, we abandon the concept of national citizenry because there's a different type of citizenry, supranational citizenry. In this context, national citizens and supranational citizens or citizenry, must complement each other and coexist because there's a feeling of double belonging for citizens. There's your country, your state of origin, and the supranational level. And these citizenries not only complement each other, they're fully interrelated because usually to be able to access the supranational citizenry, we will need to belong to the national citizenry. That's the case of the European Union, although I will elaborate on this later on. This generates obligations based on mutual rights. There's mutual recognition duties. That is, all states must recognize other citizens as their own. If we analyze this attempt of supranational citizenry, we will see that it happens as it happens with national citizenry. There are no two cases that are the same. We cannot establish a process that can be extrapolated to others. These must be taken and approached individually. We may see experiences where citizenries have been forged gradually through regulations and have been institutionalized. For example, in the case of the European Union, as you know, the European Union has established everything very clearly. Or in Mercosur, there's a citizenry status that is grounded on a residence agreement from 2019. But we can find other regional and economic experiences that are different, where there is no institutionalization of citizenry, but there's a de facto system, for example, on what happens in ASEAN. So, setting these foundations and having defined the general theory,
Ahora les voy a poner.
I want to emphasize a study and a classification that was developed in the Oxford Book of Citizenship. It's a topic that it's a book that I recommend. It talks about economic integration based on how they address freedom of movement. Because if we study the development of these law and integrations, we get a pretty clear idea of the point of evolution that they're in. We have a first level of integration, as I mentioned this morning. Only freedom of movement is recognized in an economic way. That is, only workers have freedom of movement. For example, NAFTA is at that stage. NAFTA only recognizes this to 4 specific groups of workers. Then there is a second level where we find general rights, that is, all citizens can have this freedom of movements, and there are subjective rights. This is the case of Mercosur. And we must point out that between the first and second level, there is an infinite scale of grace, because there are integrations that are not in the first level. They're beyond the first level, but are not at the second level yet. And if we classify the integrations in levels, we must create one specific model for the European Union, because in the European Union, not only there's a right of freedom of movement, in addition to that, the citizenship is institutionalized, but the ownership of right is expanded to third country nationals who have permanent residence in the Union, and there's an active migration policy, for example, in terms of asylum, which is something that is going to be addressed by my colleagues later on. So a third level of evolution must be created that is exclusive to the European Union. And this is the general theory of the treatment of freedom of movement in economic integration. And this we will extrapolate to the history and the evolution of the European Union.
The origins of the freedom of movement, or the free movement of people, can be found at the treaty for the community, for the founding of the community of steel and coal, that allowed for the workers of that industry to freely move. But it's only for those kind of workers in that industry. The steel and coal community was an area of free trade, free of customs, but not free of tariffs for all products. It was an imperfect area of free movement. So in that case, people are not seen as citizens, but as economic partners or economic actors. But the doctrine says that citizenry found its origin in that coal and steel community. That was the first step for the free movement that we can find today. There was an insistence and an interest to organize the free movement of people already at that time, that it was included in the Treaty of Rome. And we have to mention the Treaty of 1957, Article 39, talked about the free movement of people, of workers, as one of the main economic freedoms that sustain the economic European project, together with the free movement of capitals and the free movement of goods. But it was subject, or it had to rely on having a job offer in another European country. So again, the citizens, people, are economic stakeholders. They're not just universal citizens. But we can find two main differences in this treaty. So free movement of people is now expanded to all types of workers, not just coal and steel workers. And that freedom of movement meant that when one accepted a job offer in another member state, they were to be considered under the same conditions as those country nationals in rights and duties. So there is some progress there. At that stage, there is the work of the derived law and the Court of Justice of the European Union, because this is the first glimpse of the concept of the community citizenship or the community citizenry, where you can have a right, you can exert a right, and the right to move freely, and it also has some subjective rights. Regulation 1612/68 removed all barriers or obstacles for the workers' family members to freely travel with them. If the workers were to work in another member state, they should benefit from the same tax and social benefits. So that is an economic right, the freedom of movement, that has some connected subjective rights. So this is the main piece of this evolution of the freedom of movement. Back then, at that stage, there was a broader interpretation of that right, with an emphasis on the social dimension, not just on the economic dimension, because it broadened the ownership of the rights. There was more people were considered to be workers. For example, the freedom of movement was not only for people who had accepted or received a formal job offer in another member state, but also to those who could potentially receive a job offer or who could go to another member state to find the job, to look for a job. So it is more social and less economic. So this right was given to not only formal workers, but also to the unemployed, to the youth, and to people who had retired. So these were the fundamental treaties. And then the Maastricht Treaty and the Amsterdam Treaty consolidated the Schengen acquis in the framework of the European Union and created a space of freedom and justice with a moratorium of 5 years to remove all barriers in the borders. And then in 1997, group presided by Simone Veil, one of the recipients of the Charles V Award, proposed 80 recommendations to improve the effective application of the free movement. For example, broadening the right of residency to also the non-married couples. And then in 1997, the emphasis was put on one of the difficulties encountered by the citizens when it came to exerting that right: the barriers imposed by the internal laws, the national laws that were different from country to country. So I will summarize it because I've done a lot of research on the origins, because I wanted to see that the European project did not really start with the Treaty of the Functioning of the European Union. Its roots lies in the coal and steel community. And now we need to talk about the European citizenship. If we analyze this process, it has greatly changed. All these initiatives respond to the goal of creating not just an economic Europe, but it's also a social Europe. The purpose of making it more accessible to the citizens and with more competencies and impact in people's lives. The turning point is in 1998 with the Treaty of Maastricht, where the first notion of citizenship or citizenry appears. There was freedom of movement, freedom of residency, of passive suffrage and active suffrage, a right to diplomatic protection if the people is in a third state where the original member state is not represented, and a right of petition before the European Parliament and access to the European Ombudsman. So as Professor Campos said, this is not just a right, but it is linked to the rights, because these rights recognize the integration. This is the phenomenon that started out at the beginning. This is where the European citizenry starts interacting with the national citizenships. Because if you are to acquire the European citizenship, you need to be a national, one of the member states. So the European citizenship is a derived citizenship. During those first years of this citizenship, we could see one specific phenomenon. There were two different profiles of European citizens because of this connection with the freedom of movement, because there was a huge gap between the citizens that lived in their countries of origin and those who had moved freely to another member state, because political laws are used for the latter. And that right of diplomatic protection also applies basically to the latter. And then, as we have seen in these many years, the second profile had several benefits or advantages versus the first ones, versus the former, especially when it comes to reuniting a family. And this was highlighted by the Court of Justice, who progressively modulated the connection between the citizenry and the freedom of movement. At the beginning, if we were to apply the law of the European Union between the law of a European member state and citizen, there has to be the citizen needed to have exerted that freedom of movement, because there was no cross-border interaction. So the law of the European Union was not applicable. It was just a domestic situation. In domestic situation, domestic laws could potentially discriminate. For example, the access to social subsidies to the non-nationals or to some nationals. So as I was saying, the Court of Justice progressively modulated this in, for example, certain rulings, for example, in Martinez Sala and Down Bust, that have been qualified as the turning point towards this citizenry, because the Court of Justice expanded the effects of the horizontality of the freedom of movement, because it is no longer a cross-border issue. It is no longer a cross-border advantage or right, because that freedom of movement could not only be justified for economic reasons, it could be also due to social reasons or any other reasons. So this changed the interaction between the nationals of the member states of the European Union with the rest of the member states. And now I will focus a little bit more on a ruling called the Ruiz Zambrano ruling. So the citizenship status was not only applied to the subjects that are economically active or not. The Court of Justice said that the measures of your original member state will deprive you of your rights as a European citizen should be perceived or assessed from the lens of the European law. So this is a connection between the European Union law without having to move from one country to another. So Article 20 of the Treaty of the Functioning of the European Union says that there is no need for a cross-border situation to exist for it to be applied. If you need the protection of the European citizenship, you don't really need to move from one country to another because you can have access to it, you can enjoy it without having to move from one country to another. So you are integrated. You're integrating all the citizens. It's a transnational integration of a citizen. If the link between the European citizenry and that movement, if it's removed, and then you can have that European citizenry just because you exist and not because you have moved from one country to another, but just because you are a national of a member state, then you can say that you have a plurinational citizenry. That is the argument used in the Ruiz-Zambrano ruling. So citizenry is the fundamental status of the European citizens. So what I am understanding here is that citizenry is not linked to the right to move. You can have that European citizenry because you are a member of a national of a member state, just because you have been born in Spain, just because you are a national of a member state. And that means that the European citizenry creates a sense of belonging to the European Union. And that sense of belonging is important because you can find that sense of unity between nationals of different member states so that we can have a European demos. That is also moving at the same pace as the integrations, the progressive integrations of the European Union. An economic integration, currency integration, a social integration with a clear structure, with a common political project, with political unity. And that can only be achieved by fostering citizenry and the sense of belonging, which in turn relies on the free movement. We need a common status and a common culture. With the evolution of the rights of workers, they were not only looking for an economic benefits, they were looking for social benefits too, because they were aware that when someone moves to another country for a job offer, they would develop some social connections with the recipient country, thus a sense of belonging. And finally, the current situation, the Charter of Fundamental Rights of the European Union and Article 20.2 of the Treaty of the Functioning of the European Union. So, fundamental rights, freedom of movement is in Article 45 of the Charter of Fundamental Rights of the European Union. More than the right to move freely is a right to move freely plus a right to choose where you want to live. So that is the free movement that we can do at the borders or within the states, from moving from point A to point B within the national borders. And you can choose where to live. It's two different rights, but obviously interconnected, because when you choose where to live, you need to have the right to move from one place to another. And the holders of the rights are the European citizens and their family members, their relatives, regardless of their nationality, and also nationals from third states. So this is a horizontality of the effects of freedom of movement. The nationals coming from third states who can legally reside on the European Union. So that is the horizontality. Those are the effects of horizontality of the fundamental rights. They have widely expanded. What about the limits? No fundamental rights are absolute in their conception. They have to be limited, and they are limited by the treaties and always under the principle of proportionality. Regarding freedom of movement, it can never be limited based on discrimination on the grounds of nationality. It has to be based on the grounds of something objective. But I would like to focus on the indirect limits. At this point, you might have realized that these rights cannot be understood isolatedly. It is a cross-sectional transversal right or a rule as a breach. It is a necessary right that we as European citizens can also exert many other rights. For example, that you can choose where to live or your personal freedoms, where freedom of movement is essential. But I also need that for other rights. Or let me explain it with different words. I need other rights if I am to enjoy this right. My other rights have to be guaranteed so that I can move freely. For example, I need social rights and the right to have a private and family life. Social rights. This is not a coincidence because all the rulings, Ruiz Zambrano, Martinez Sala, that have built this European identity were connected to the rights of the people that settled in a country different than their country of origin. Those rights are subordinate and accessory at the beginning because it was only just an economic integration. But as soon as we aspire to get a single market, we start to see that social dimension of the rights. The access to the social rights is of paramount importance. So we need to understand this in the light of the evolution of the integrations. If we analyze the rulings of the Court of Justice, we can see that evolution. Depending on the stage, the integration stage, the interpretation of the Court of Justice has been evolving. People who had moved from one country to another, for example, had the right to be covered by the social security system in the recipient countries. So the Court of Justice made it possible for those rights to be guaranteed for those people at the early stages of the integration process. And then after the recession in 2008, the interpretation changed. The Court of Justice, among many other things, decided to restrict the movement of people and they didn't automatically got covered by the social security systems in the recipient countries. For example, they could only be covered by those social security systems if they had a permanent residency and if they were economically active. That was, I repeat, a consequence of the economic recession of 2008. It was very criticized because by limiting that access to the social security system, you are actively limiting the freedom of movement because you cannot freely move if you won't have any social security protection in the recipient country. The same goes for your family members. If you remember the derived law and the previous rulings, all the obstacles for the family members to accompany the active workers had been removed. But again, now in 2008, the notion of family member was revised because many countries decided to limit or to restrict the notion of family member, spouse, or relative. And the European Union could not influence the notion of a family member as decided by the individual countries. So, for example, if your legal marital status is only recognized in your country of origin but not in the recipient country, that is a source of discrimination. So the Court of Justice decided to broadly recognize all notions of family members and marital status. You might remember the Brockman ruling that recognized the notion of spouse. Spouses are all types of spouses, even people in same-sex marriages. So that forced many countries to recognize the same-sex marriages. And the same goes for children, all types of children or offspring. Because the freedom of movement is not an autonomous right, it's a cross-sectional or transversal right. So it has to be interconnected with other rights if you are to fully exert it in such an advanced society as the European Union. And in my conclusion, I will just say some reflections or food for thought for you. Because as we have seen, freedom of movement is not just a right about passports or the Erasmus projects or for touristic reasons. It is a completely cross-sectional structural right of the European Union that is the result of years of evolution with a clear political vision, because Europe is also built upon the rights of those who live in it. And citizenry means that you belong to it. And belonging to something means living there, freely moving from one place to another. A democratic Europe means that that freedom of movement can be inalienable and not just a temporary granting subject to the crisis or the circumstances. So freedom of movement for it to be able to keep on progressing and advancing after the consolidation of the different stages of the economic and social integration of Europe will keep on progressing, will keep on moving. It cannot encounter any invisible walls or even visible walls as we can find now. Thank you. I remain at your disposal.
Pues muchísimas gracias, Yolanda. Como diría...
Thank you, Yolanda. As General de Gaulle would say, it's a vast program because there are many things that we could say about it. But first of all, congratulations. And maybe, I don't know, I will give you my condolences because you have embarked on quite an adventure. It's very interesting. It will be a source of many reflections, some doubts. And I will be making a first question now. When I was listening to you and thinking about what you said, I was wondering if we have really removed the idea of the integration, the European integration, from the economic notion. You talked about the restrictive interpretation of the rulings after 2008. That was a step backwards. I have some European students in my university in Valencia, and oftentimes they were asked to demonstrate that they had the means, the economic means, to be able to study in Valencia. So yes, we all say beautiful words about the idea of the European citizenry or citizenship, but the way I see it is it was born from a political imperative almost for the survival of the European Union in 1992, where there was a conflict only a few kilometers away from Italy, where the European public opinion, in the opinion polls, respondents said that the idea of a European project was at the bottom of people's concerns. And then in 1991, 1992, there was like a renaissance of the nationalism in several countries. So it was a political imperative. And we have a situation here because when you say that what defines this citizenship is the idea of that belonging to Europe, to a territory, but so far the European Union doesn't have clearly defined territory. If territory means the territory of the member states, I'm talking about Greenland here and all the interferences by Mr. Trump. It is a reflection or a symptom of that problem. The European Union doesn't have a legally defined territory. And the paradox is that we're still looking for, we're still trying to define that notion of citizenship. The idea of the European citizenship since 1992, even if the European case law tries to pinpoint it, is quite empty, in my opinion. We're still defining it with most conspicuous features: freedom of movement within the territory and outside of the territory. So I hope that maybe in the future, maybe in a few months' time or a few years' time, I hope that you will be able to talk about a new perspective for that notion of citizenship, because you've been talking about the past. Think about Schengen too. It's clearly collapsing, which is also a symptom of us having a problem with that notion of citizenship.
Because I remember that in 1993, when Schengen was started, we discovered, we Europeans, we discovered that systematic controls were eliminated in the borders. The control was eliminated, but not borders. Borders remained. However, media tried to blur this, and what they said was that borders were eliminated. No, borders remained. It was the controls that were suppressed. So what will happen in the future? Well, there's a lot to work on. I give you the floor now. Regarding your first question on whether we have decoupled the economic dimension from freedom of movement, of course, no. The answer is no, clearly. The study of freedom of movement in the European Union started with the stages of economic integration because it's impossible to decouple these two aspects. Although we talk about a fundamental right, Article 45 of the Charter, as you said, it is really beautiful in writing. However, it is still very theoretical because in practice there are multiple situations where this has not been decoupled. There is certain priority to those citizens that are economically active. And what happens to those who are not? So that's why this study departs from the economic study, and I am fully aware that this is a fully theoretical study, because if we go down to reality, we will see how there are multiple situations where this has not happened yet. And the consequences are indeed general consequences for citizenship. Freedom of movement is only one of the multiple factors that affect citizens, because there are other political aspects, like, for example, the right to vote and stand for elections, the right to vote and stand for elections, and that is something that is still to be developed. Regarding the feeling of being European, I think the implementation of this is fundamental for the survival of the EU. How can this be built? Well, not only from law. I think lawyers tend to be very theoretical, but of course there must be an approach that is multiple and includes history, sociology, and so on and so forth. There is a social repercussion of what I'm studying. Does law solve all problems? Not always. I based my study in the past because I think it helps us to approach the present in a different way. And it helps us to know where we are heading in such a complicated situation as the one we have right now. One little question or suggestion. In the beginning, you said that freedom of movement for people is necessarily connected, or I understood it this way, to an economic dimension. My question is a paradox in a way, because freedom of movement is recognized in the Universal Declaration of Human Rights, 1948. There's no economic dimension in the Declaration of Human Rights. And in 1950, we see how the economic dimension is included unless there is a liberal reading of this text. But this would be very bold. It's bold to say this. A liberal interpretation of the European Convention of Human Rights. Going back to that point, and in support to this connection between freedom of movement or economic dimension and this fundamental right, our French neighbors and friends, with the Déclaration des droits de l'homme et des citoyens, the Declaration of Human Rights and Citizens, already attached a very liberal and or economic vision of these fundamental rights. When you see the constructions of many European countries, for example, the most beautiful country in the world, which is Belgium, of course, our construction is highly liberal. The focus is in the economic dimension. You can give economic interpretation of all those rights, and this supports the notion of freedom of movement. Are you going to answer, or should we start with the interventions from the audience? Very fast about the Universal Declaration and the European Convention. I am fully aware of all the human rights international instruments that talk about freedom of movement. In fact, my doctoral thesis focuses on our constitution, Article 19 of the Spanish Constitution. And this is a study, an international study that is independent. But I focused on the economic aspect because the study focuses on the European Union and its evolution as in economic integration. But I'm very lucky, or I don't know if I should be talking about luck, because it is a very broad right, and it can be interpreted in different ways. I think it is hard to limit the study, because since it's a cross-cutting transversal right, multiple debates may arise. It's connected to many other rights and multiple disciplines. Professor Freixes, thank you very much. This intervention was very, very suggestive. I miss the underlying political dimension. Obviously, if European integration legally starts being implemented in economic aspects, is because there's no agreement on political matters. The Hague Congress focuses on that. If we remember Victor Hugo's speech on Parliament, well, that gives us an idea of the situation. The idea dates from way back in the past. This idea is very much connected to everything that was done economically. Whenever steps forward were taken, there was always a blockade because there was not enough consensus to move forward in that way. However, in derived law or secondary law, this idea of freedom of movement is present in so many fields that this forced the concept of right of citizenship. That is not a right that is necessarily connected to economy, but to the fact of being a citizen. For example, more recently, the European Directive against violence against women and domestic violence. This directive is grounded on the fact that the exercise of one of our rights, for example, freedom of movement, may not undermine the rights that a victim may have on their own country when this victim goes to another country. So there's no economic dimension because many of these rights do not have an economic content. For example, there may be some economic support, but many measures may have to do with protecting children, access to work, and so on and so forth. So this political ambition of freedom of movement is always very present. I would recommend you to consider the conclusions of the Conference on the Future of Europe that finished very recently, and the judgment of the Council Legal Services on the outcome of this conference, because there are many references on freedom of movement in fields that have nothing to do with economy. It is a very interesting work, what you are doing, because this is clearly something that will not disappear in the European Union, but on the contrary, it will intensify, although in some cases it will have to be limited for just strategic reasons or whatever sort of reason. Thank you very much for your recommendations, because as I mentioned in the beginning, I am a lawyer, an expert in the Constitution, and I'm part of a research group where there are many economy experts. That's why we started with the economic approach of freedom of movement. However, the degree of regional and economic integration in the European Union, what is necessary now is a political project. That's why there have always been underlying political reasons to freedom of movement, because this is connected to multiple rights and multiple European elements. I just wanted to mention that the political project has been created. It's just a matter of concretizing it. The political project is there and is the driver of the European integration. Indeed, and thank you very much for your recommendations. Good morning. My name is Bettina Step. I'm a teacher at the UOC. Thank you very much for your presentation. Echoing what Mrs. Freixes was saying, I would like to know whether, in connection with the concept of citizenship of the European Union, you had considered the judgment of the Court of Justice on golden visas, because I think that by connecting European citizenship to values consecrated in Article 2 of the Treaty of the Union, we can expand this notion of the political vision of citizens and freedom of movement. Again, thank you very much for your recommendations. This is a project that is at an early stage. I am aware of that judgment. It is very important for the topic that I'm working on, because this is connected to European values, and European values is what creates the European citizenship, which is the what needs to be developed. I hope to have the chance of developing this with the depth that this topic deserves. I'm Rosa Maria Martinez de Codes. I come from the Complutense University of Madrid. I am a historian. I'm not an expert in legal aspect, but I do have some connections, and I do have some knowledge and background in the field. I want to congratulate you for your presentation. From a educational perspective, this is a very complex topic, and your ideas were very clear and very precise. However, your approach may not be the one that people here want to hear. Your approach rebuilds or attempts to make us understand what the legal architecture, so to speak, that made it possible to develop a transversal right, that freedom of movement. And this freedom of movement leads us to the development of European citizenship. Professor Freixas is very right when she says, beware the political approach. Well, you work from the legal perspective, but you don't have political sciences experts there. And the political approach is fundamental to talk about the right of citizens, not only in connection with freedom of movement, but in connection with many other rights connected to the European construction. When Frédéric was wondering, what is the European Union? There are many definitions of the European Union, and there is one that I like the most, because it's an open field. When the field is open, you have more chances of finding adherence. It is a political entity in process. What is the political field? Well, it depends on who speaks. It depends on whether we're talking about states that can be permitted in the south or east borders. All of these things are important. And I believe that if your project aims at having a social impact, if you want to have an academic impact, a social impact, if you want to have an impact in whatever spheres you're working in, you need to pay very close attention to the development of citizenship in Europe. We are in dire need to create a European citizenship, because the legal construction, I don't know why I interpret the judgments of the Court of Justice. Who does this reach? If we talk about the legal construction, it's harder to reach others. Social construction requires a totally different input. And in your project, you need results that go beyond. Thank you very much, because your presentation was beautiful. Thank you very much. And precisely, this is why in the beginning I was saying that this seminar is incredibly useful for me because my weakness is that I'm a lawyer and I am a little wary to not be precise enough when I deal with other areas. These are some general guidelines of a project that is just being conceived. So I'm really grateful for your recommendation that I'm fully aware that I have to include the political dimensions, particularly when dealing with the evolution of citizenship. Transnational citizenship that moves to transnational and supranational citizenship. The European Union is not an economic project, and it has to become a political project to make sense, to have an impact, and to be developed. If we stay at the highest levels, law or theoretical law, without going down, without a political project, it doesn't make sense. So I really appreciate your contribution. Thank you very much, Yolanda, for your presentation. My name is Rodrigo from the Complutense University in Madrid. As a historian, I'm very interested in your topic. There are two historic moments that could be useful to analyze that political dimension of citizenship. And then there's a source that I would like to share with you. The two first elements are the transition periods suffered by Greece and Spain after the accession to the European Union, because those two periods are very similar, but restricted freedom of movement, not only in terms of horizontal mobility, but also cross-border mobility. There were many debates on this, and this brings me to a historic source. For historians like me, this is rough. It's the legal services of the European Commission, because once the legislative initiative happened during the 80s and 90s, when citizenship and Europe without borders was being designed, this was the first filter when what the risks were and so on and so forth. Thank you very much. No, thank you. Thanks for your vision as a historian, which I clearly lack. So we can discuss later on. Good morning, and thank you very much, Yolanda. I'm Karen Añaños from the University of Granada. Two questions. I want to congratulate you because you summarized so many things. You talked about integration processes. You also mentioned Latin America, which is a totally different world. I think this part of your work attempts to show us this evolution and comparing it with integration processes that are absolutely different, that are radically different, like the ones in Latin America. There are so many things to say. Each of the topics you touched upon have a very high level of complexity and many aspects that could be addressed. But maybe you should take into consideration the book by Castor Diaz-Barrado, who's a specialist in integration processes, particularly in Latin America. He did some research on Europe and Latin America. I think it's a wonderful reference that has to do with your work. I don't know if you will include, well, we are talking about European citizenship, freedom of movement. Are you going to include aliens? Because it's not only Europeans that use freedom of movement in Europe. There is movement of people who are foreigners in the European Union. That's more connected to my field of specialization, that is private international law. As Frédéric said, that would involve talking about borders, visas. It is a whole different range of topics. Just if you wanted to expand your field. Thank you very much. Regarding Latin America and Professor Castro, I love to hear that because he was my teacher. I know him and I am very well aware that he's an expert in the field. Of course, I will read him about integration in Latin America. It is something that I'm very interested in. I have read a little bit about this. And when it comes to economic or regional integrations, there's no one single process or one single processes that can be extrapolated because each integration has its own consequences, not only economic, but also structural, territorial, etc., that really have an impact in the whole integration process. So I wanted to stick to the European Union, which is that I'm closer to and more familiar with. Regarding third country nationals and external borders, this is something that I need to address. I am a little bit scared of doing so, but I know I must do it. I focused on internal borders in my presentation, but I think it's fundamental for my study to be complete, and I have to address all institutions. So thank you very much. Another question came to mind. It's a suggestion more than a question. When you talk about the Court of Justice of the European Union, and going back to citizenship, do you realize that here in this space we talk more about citizenship than about freedom of movement in itself? There's a reason for this. And the other message for you is that I think you should work a little bit on the cross influence and interaction between, I don't know if you should explore the constitutional jurisprudence of the different 27 countries. There's a dialogue between constitutional tribunals on this. Maybe you should study these rulings. There's this cross influence between the Court of Justice of the European Union and the constitutional courts. Maybe you should also study the cross influence with the European Court of Human Rights. There's this concept of citizenship together with other concepts that we deal with on a European level, and these are impacted and have influences when they interpret different cases. There's no working silos, so as to speak, between different the different legal systems. There are mutual influences. Thank you very much for your suggestion. I stuck to the judgments that I considered more interesting from the Court of Justice in this legal integration, but I need to go down to the ground, and that would bring me to the dialogue between courts as such. If there are no other questions, I would like to say something echoing what Karen was saying in connection with this vision of European citizenship, but from abroad, or from the exterior, because sometimes I have the feeling that Europeans have a perception, and from the exterior they have a different perspective. And I'm thinking about, for example, in the case of Spain or in the case of Latin America, there are many people who want to apply for Spanish citizenship, which involves being a European citizen. And I think they are more aware of the advantages of having a Spanish or European citizenship. And it would be interesting to compare the different perceptions of what the European citizenship involves. Sometimes from the outside, things are perceived in a different way, and positive aspects seem to be seen in a more positive way. There are many people who are waiting in line to have this European citizenship by getting, for example, the citizenship of Spain in this case, which is something that is being dealt with a lot right now. And then from the outside, for example, in my generation, the European citizenship for me was taken for granted because I was born in a moment when Spain was already a member of the European Union. So I did not perceive anything other than that. I was born under the right of the Union. And I have the feeling that in my generation, this is being taken for granted. And there's this disaffection with the European Union sometimes because there's a lack of knowledge, because we don't know how it impacts our life when it has so many impacts. I think this is why this seminar is so important. So thanks so much for your comment. I think there are no further questions. Do you want to close with one final comment? I want to congratulate Yolanda once again, and I want to thank the audience for all those wonderful contributions. It is clear that Yolanda's work is legal from it has a legal clear nature. There are some slight references to political aspects. I'm a lawyer like you, but I must recognize the fact that the political dimension is important. I have a relative who passed away, who was working in the Court of Justice back in the time of the European economic communities. And they built this economic approach, and at the end of the 70s, they wrote the Economic European Constitution. And something that I learned from them is that it is clear that there's a political project, and the political project is established, but the economic dimension is very present. And I think that when we talk about citizenry and when we talk about the public opinion, we have member states. They are what they are. So we have to work on this political project and this economic project. Without discontent, the political project fails. And in the last European elections, we saw good evidence of this. So thank you very much. And we are going to leave the stage to the next presentation. Thank you very much for your attention.